a story, Your Honor. It wasn't my fault. I never went near her garage on the night in question.
Are you saying that you've never used Mrs. Anderson's garage as a canvas for your artwork?
No, Your Honor, I'd never do that without permission. Though my paintings are good enough that I'd think anyone would be happy to have me paint their wall. Especially Mrs. Anderson. That's a real ugly garage.
You testify that you always sign your work. Look at this picture. Is this your signature?
Well, it looks like mine, but honest, Your Honor, I never had anything to do.
Did you know that about 3/4 of the plaintiffs in small claims court win? That doesn't mean the judges are biased in favor of the plaintiffs. It probably means that most people don't bring a matter to small claims court unless they have a good case. And it may also mean that you should consider small claims court as one way to right wrongs. You'll learn how from Judge Wapner on this cassette.
Small claims courts vary somewhat from state to state, and sometimes even between cities and counties within a state. They are all intended to resolve smaller cases, usually those with damages under $2,000 or $3,000, quickly and inexpensively. Parties in a small claims action generally represent themselves without an attorney. The procedures are much less formal than in regular courts, and a judgment is rendered after one short hearing. Appeal rights are limited, and judges tend to do what seems fair in the individual case and not let legal technicalities or precedents produce unfair results. They tend to reward people who've acted reasonably and tried to compromise, and to punish parties who've taken advantage, stonewalled settlement attempts, or acted unfairly. These are typical of the cases often brought to small claims court by individuals.
My landlord won't return my security deposit after I moved. He claims I left him with extra cleaning and repair expenses.
I left my car in a parking garage and the attendant damaged it.
I bought a trash compactor that's never worked right, and the store won't replace it.
I had a friend who needed a short-term loan and had no one else to turn to. I loaned him the money, and now he won't pay the debt.
I took my car to the mechanic and paid a lot of money for auto repairs, but the car still isn't fixed.
Even though small claims court offers a relatively quick and inexpensive way of resolving disputes, it's still likely to involve at least 2 trips to the courthouse, some minor expenses, and quite a bit of preparation time on your part, not to mention the anxiety of presenting your case to a judge. Most of us don't need to be reminded that settling without suing is often preferable. But some of us aren't as good as we could be at getting people to react favorably to our demands. Or maybe we aren't even aware of mediation programs and other ways of resolving disputes short of litigation. I want to address both of these subjects now. In the tape, Your Rights as a Consumer, I gave 10 rules for effective complaining to businesses. Most of those apply to complaints against individuals as well. So let's review them quickly.
Assume people want feedback.
Express yourself clearly and politely.
State the real problem.
Decide what you want done.
Keep relevant documents.
Approach the right person.
Be persistent.
Use the right medium.
Stay emotionally detached.
Know when to get allies.
Now let's apply these rules to a common situation that often becomes a small claims court dispute: a landlord's refusal to return a security deposit. Let's presume you're moving out of your apartment because you've just gotten married and need a larger place. You've been generally satisfied with your old premises, which had a resident manager. Let's call her Mrs. Smith. You're not sure who owns the building. You've given the proper written notice, worked to make the place distinctly cleaner than when you moved in 2 years earlier, and are ready to turn in your key. If you're smart, you've gotten to know the manager pretty well and are on good terms. You've brought maintenance needs to her attention in a polite, low-key way. Now's the time to express your appreciation for her work. It's also the time to inquire about when you should expect to receive a refund of your security deposit. Suppose that Mrs. Smith says that the corporate office will mail you a check in a week. Now, I think you'll agree that the likelihood of a dispute occurring over the security deposit in this situation is pretty small. But let's suppose that the building has recently been sold and the new owner is a bit strapped for cash. He's decided to hold up all deposit refunds as long as he can. In California and a few other states which have laws that protect tenants fairly well, this is probably not a very good strategy, but it's still very common. In the meantime, you're very busy with your new life, but after 2 or 3 weeks, you begin to wonder about that deposit. Does the delay mean that it is time for you to fire off an angry letter or rush to small claims court? Of course not. Your first action should be to call your old manager, Mrs. Smith, to see if she knows anything about the situation and to find out who to call next. Be sure to ask whether she's inspected the apartment and found any problems. Next, call the owner's office. You don't need to complain or make demands with this call. You're just inquiring why you haven't received a check. The response you get to this question determines what your next step will be. If you don't get a satisfactory answer, you don't want to get stalled too long without putting something in writing. You should have kept track of each call, when it was made, who you spoke to, and what was said. Your first letter should be polite, but firm, clear, and brief. Be sure you send it to the right person, and it is certified by the post office. The letter should identify you, the apartment, the date you moved out, the amount you're owed, and the efforts you've made to obtain your refund. Then make a specific request for payment and give the owners a reasonable deadline. You probably shouldn't threaten to sue at this point unless it's already become evident that only a lawsuit will get you your money. What you are doing is building the documentary record that you will need if you actually have to go to court. Of course, you should keep a copy of your letter. You might even want to send Mrs. Smith a copy, since you will want the manager to speak up for you with the owners if this goes to small claims court. If your deadline passes and you still haven't received your check, don't bother with any more phone calls. Send a brief letter that refers to and encloses a copy of the first letter. It should say what you'll do if you don't get your money by a new deadline that you set in your letter. Then be prepared to take that next step. Don't make idle threats. You may want to point out that if you do have to sue to collect, the landlord will have to pay your court costs. You may also want to send a copy of this letter to a consumer agency, the Better Business Bureau, a tenants' action group, or the local association of landlords. The actions that I have outlined accomplish several goals. They make any delay in receiving your deposit unlikely. They make it easy for the landlord to respond favorably, and they build the background and documentation you need to succeed if you do have to go to small claims court.
At this point, are there any alternatives to small claims court?
Yes, there are, and each of them works best for a certain class of disputes. Furthermore, not all are available throughout the country. We'll come back to our security deposit example in a couple of minutes.
The alternatives to small claims court are consumer action panels, consumer action agencies, media programs, arbitration, mediation, and court programs. Judge Wapner will talk about them one at a time. First, consumer action panels, which are industry-run programs for resolving disputes.
The largest of these are AutoCap, which is run by automobile dealers, and MayCap, which is run by appliance dealers. These panels contact the manufacturer when they receive a consumer complaint, then have a review board recommend a solution. The board's decision is not binding on the consumer, but it may be binding on the manufacturer.
Consumer action agencies exist in all states and many localities. These agencies will investigate individual disputes and try to mediate a settlement.
These government agencies have been under severe budget pressure for some years now, and generally must restrict the type of matters they handle and the amount of effort they expend. Some of the government units have formal investigative power. Private groups also exist and vary greatly in their scope and effectiveness. Don't try to force a group to take up your matter. You'll only waste your time and get frustrated. You want a group that is eager to get involved.
To get more information on consumer action agencies, write the Consumer Information Center, Post Office Box 100, Pueblo, Colorado 81002. They'll give you information on public and private agencies that help consumers, including information on private dispute resolution programs, a listing of Better Business Bureaus, and trade associations. The next alternative to small claims court is one of the media programs.
Some television stations and newspapers run consumer hotlines. They like problems that have dramatic potential, although they're seldom able to investigate the vast majority of matters that come in. If your problem is one that appeals to them, however, they can do wonders. The threat of adverse publicity can turn around a merchant's attitude very quickly.
The next out-of-court remedy is arbitration. Arbitration programs are increasingly common. They're the standard way of resolving attorney fee disputes and claims against dry cleaners and stockbrokers, among others.
An arbitrator acts like a judge, but the setting is less formal, and the decision that is made may or may not be binding on either party. Today, many contracts require that disputes be submitted to arbitration. You can get a list of arbitrators and an explanation of the rules from a sponsoring agency, usually the Better Business Bureau or the American Arbitration Association. For a local address and telephone number of these agencies, check your phone book.
Mediation is another avenue to consider if you want to avoid court. A mediator tries to get the parties to reach an agreement themselves. Unlike the arbitrator, the mediator does not make a decision for them.
Mediation is particularly useful when the parties need to continue to deal with each other, partly because people are more likely to adhere to an agreement they have made themselves than one that was imposed on them by someone else. Some mediation programs are run by courts, others by non-profit groups, and an increasing number by private, for-profit organizations.
A final choice to consider is to take advantage of the court programs. An increasing number of small claims courts are offering arbitration and mediation options. These are usually optional.
In the case of arbitration, one objective is to save time and money. Mediation programs are intended to let the parties reach solutions that small claims court judges could not impose or that would not work without an agreement. If none of these alternative methods of resolving your dispute will work, a small claims action may be your best choice.
The key to winning in small claims court is bringing the right case in the right way. Of course, to a large degree, you must accept the case as you find it. But, as we've already seen, you can improve your case by the actions you take and the records you accumulate before you file. Any lawyer will tell you that most cases are decided on the facts and not by the persuasiveness of the advocates or witnesses.
You should be evaluating your dispute at every stage of the complaint process that I have already outlined. You should not threaten to go to court unless you've already decided, perhaps after consulting a lawyer, that you have a winning case and a good chance of collecting your judgment. After you file, you should continue your evaluation as every new piece of evidence or relevant fact is developed. Ask yourself repeatedly, can I settle? Should I settle? How do things look? Before you actually initiate any court action, there are 4 key questions to ask yourself.
Did I suffer some kind of measurable harm or monetary loss?
Can I prove that the harm I suffered was the defendant's fault?
Can the court order compensation?
Can I collect from the defendant?
Let's consider each of these questions in more detail.
Did I suffer some measurable harm or damage?
Most harm is hard to measure. Hurt feelings, inconvenience, and anxiety are all real, but it's hard to attach a dollar value to them. Not every wrong produces measurable harm, but courts are most comfortable when there's a clear way to gauge the damage that you have suffered. So just because someone did you wrong doesn't mean that you can sue successfully.
Judge Wapner, I went to the salon to have my hair trimmed by the hairdresser. However, when he was through, my hair looked like I'd just joined the armed services. Can I sue in small claims court?
If you specifically told your hairdresser that you just wanted a little trim, and he negligently gave you a hatchet job in disregard of your specific instructions, you might have a solid case against him in small claims court. The court would have to determine what your monetary damages should be given all the available information. Keep in mind that going to small claims court takes a lot of time and effort on your part, and in some instances may not be worth the trouble.
Can I prove that the harm I suffered was the defendant's fault?
In a civil case, you have to prove your losses by what the law calls a preponderance of the evidence. This means that the evidence of your loss must outweigh contrary or missing evidence. For example, suppose you drive an old clunker that has several major dents in it, and someone backs into it and adds another. Legally, your loss is nothing more than the decrease in the value of the car caused by the new dent, or the cost of repairing the latest dent. But when a car is already badly dented, it may not be possible to show how it decreased in value because of another ding. You might be able to get estimates from body shops, but you have to decide if it's worth the time and the energy that it will take, weighed against the amount you could expect to collect. When cases hinge on the problem of proof, many are washed out of small claims court. Always remember to consider what it will take to prove a point and what that proof will cost. To win a damage award, you must show that your loss was the defendant's fault. In contract cases, this fault can result from a broken promise. It can also be from carelessness or negligence, as it is called in legalese, or the damages may arise from intentional action. It is up to you to show the connection between the defendant's action and your loss.
I took my girlfriend to an expensive French restaurant. During the course of the meal, a sloppy waiter dropped onion soup on my girlfriend's blouse. If the dry cleaner can't get the stain out, can my girlfriend successfully sue the restaurant for the cost of the blouse in small claims court?
In this case, it looks like the waiter was negligent, so your girlfriend probably would be successful in small claims court. The restaurant, however, will not be responsible for the full purchase price of the blouse unless it was brand new. The court will take into account the age of the dress in determining the compensation your girlfriend is due. Going back to our security deposit case, the issue of fault is easy. The landlord broke his promise that he had made in the lease to return the security deposit when you moved out, as long as the premises were left clean and undamaged beyond normal wear and tear. Even if there wasn't a written lease, this promise may have been oral or may have been implied by law. Accident cases, on the other hand, often present difficult questions of fault. For example, suppose you come out of the local shopping mall just in time to see someone back his car into yours in the parking lot. You exchange names and addresses with the driver. He admits fault and tells you that he will have his insurance company contact you. But when you call him a few days later to tell him that you haven't heard from his insurer, he's got a whole new story. Now he tells you that he doesn't remember backing into your car, and he won't accept any responsibility for the damage you suffered. Unless you've got witnesses who will testify about the accident, or you have a written statement from the other driver that acknowledges responsibility, you may have a hard time proving exactly what happened. For this reason, I always recommend that you ask the other driver to sign a statement admitting his fault while at the scene of the accident.
Another sort of proof problem occurs when each of the drivers is at fault for the accident, which is the case more often than not. As you may know, some states let a person recover damages proportionately to their degree of fault, as long as the other driver was more at fault. In other cases, a person may not recover anything if they were even slightly at fault.
The point is that you have to prove fault by a preponderance of the evidence, and sometimes it just can't be done.
Can compensation be ordered by the court?
Except in a handful of states, small claims courts can only order people to pay money. They can't order what's called specific performance. That means they can't order somebody to give you a particular piece of property or to perform a particular act. Nor can the courts grant injunctions forbidding an action. Small claims courts also have an upper limit on the amount of money they can award. In a large majority of states, this maximum is between $1,000 and $2,500. These limits are increased from time to time, so I'm not going to list them state by state. You'll get this information when you first contact the court.
The small claims limit in my state is $1,500. My neighbor backed his car into my fence and it cost almost $1,600 to have it repaired. Should I sue in a higher court?
If your claim is only slightly above the maximum, it may be worthwhile to reduce the claim to fit within the court's limit rather than pay a lawyer and incur the extra expenses that more complex regular court procedures entail. You might consider handling your own case in regular court, but you'll certainly want legal advice before you do. For most people, and in most cases, representing yourself in general trial courts is not advisable. Before you decide to file a small claims suit, you'll need to contact the nearest small claims court and obtain its brochure or handout outlining its procedures and limits. This should tell you what option you have in choosing a court and other relevant information. It's usually not complicated.
The company I have a complaint with is in another county on the other side of the state. Can I sue in small claims court in my local district?
You often have some leeway on where you sue. First, you can almost always sue where the defendant lives or does business. And second, in a majority of states, you can sue where the damage occurred or the contract was signed. You may also be able to sue where the contract was to be performed. Note that you cannot sue where you live just because that's convenient. Very often you'll be able to sue there because the defendant lives or does business there, the contract was signed there, or the damage occurred there. But you cannot choose a location for the suit just because you live there or because it's more convenient for you.
Judge Wapner, if I have a choice to sue in one jurisdiction or another, what factors should I consider?
Usually, choosing to sue in one jurisdiction over another won't make that much of a difference. The only times that it will make a difference is if the law governing your case differs among jurisdictions. This is unlikely. It can also make a difference if you sue in a court which has a higher dollar limit than another. So, for example, if a dry cleaner ruins your fur coat, which you value at $3,000, you'd want to try to find a small claims court which awards judgments up to this amount, if possible.
Can I collect from the defendant?
This is another factor to take into consideration when you're deciding whether to sue. It's a factor lawyers automatically consider, but small claims plaintiffs often overlook it. If the defendant cannot be located or doesn't have any money, it probably isn't worth suing. Maybe the emotional satisfaction of having a judge agree with you is worth the trouble, but give it some very serious thought. An important study of small claims courts was conducted several years ago. It found that 70% of the successful plaintiffs in contested cases were able to collect their judgments, whereas only a third of plaintiffs who won by default were able to collect. Winning by default simply means that the other party didn't show up. I'll say more about how to collect later on. The general rule lawyers go by is to sue everybody who's involved and then dismiss defendants as the case proceeds. Evidence is developed, and the defendants turn out to be judgment-proof, which means they don't have any assets. Small claims courts don't lend themselves to cases where multiple parties are pointing fingers at each other. You're apt to have problems finding the right court and may get stuck being owed by one defendant who can't pay. You probably need a lawyer's help if you can't narrow down who to sue. Your court's rules should be your main guide, but here are the general ones.
When suing a business that's owned by an individual and is not incorporated, you should state the owner's name and the business name on your complaint.
Word your complaint this way: Steve Gripke, doing business as, or DBA, Steve's Pest Control. You can find the owner's name from the local business license or property tax office. You must get the owner's name.
If the business is operated as a partnership, you should name the partnership itself and each partner as a defendant.
In this case, your complaint would be directed toward ABC Laundry Shop, a partnership, and Peter Schuck and Ed Bennett, individually and as partners.
If the business is a corporation, you need the corporate name, which, remember, may well be different from the trade name under which the corporation operates.
Joe's Pizza may be owned by Joe Smith, Inc. If so, you need to sue Joe Smith, Inc. You should be able to get this information from records at your local government offices, but you can always get it from your Secretary of State. Most courts will allow you to amend your complaint if you get it wrong.
In an auto accident case, most states require you to sue the vehicle owner as well as the driver.
The Department of Motor Vehicles can tell you the owner if you have the license plate number.
Finally, if you're suing a minor, you need to name and serve a parent or guardian as well.